Okay, folks, I'm thinking of going ahead and getting started. Thank you all for being back by 2 as requested. I think we'll have some of our colleagues continue to trickle in, but it is Friday and it's gorgeous out, so I know we probably all don't want to run really long at the tail end of the day, so we'll have our discussion of AB 52 next, and then after that is going to be a discussion of case studies. I think we'll probably have time for 3 of those, and then that will be the culmination of our workshop today. So the presentation about AB 52 is going to be presented by Samantha Cypret. She's an analyst in the legal department of the California Native American Heritage Commission. Ms. Cypret is a verified member of the Chi-Occam Maidu of the Taylorsville Rancheria and served as secretary on the tribal council. Prior to joining the NAHC, Ms. Cypret served as the program coordinator at the California Indian Law Association. She graduated from Lincoln Law School in Sacramento in 2014, where she was the recipient of the Vince Bertolani Award for the most outstanding graduate. Nice. While in law school, she worked as a law clerk for Hefner, Stark & Moreau, LLP. She was also the senior editor of the Voir Dire, Lincoln Law School's legal publication, and the dean of the Earl Warren Senate of the Delta Theta Phi Law Fraternity. She served as a certified legal intern for the Sacramento County District Attorney's Office, working in the misdemeanor and domestic violence units. And prior to law school, she graduated from the University of California, Davis with bachelor degrees in communication and political science, which makes 3 of us UC Davis alums on the speaker panel today. That's pretty awesome. So Samantha, if you want to take it away.
Perfect. Thank you guys so much, and thank you for having us and for Chapman for hosting. You'll notice myself and Terry Robinson, General Counsel, we wrote this PowerPoint together for the interest of true credit. She wrote most of it, and so I want to make sure to give her credit where it is due. So my name is Samantha Cypret, and I work with Terry Robinson in our legal department. One of the caveats we always like to make prior to actually getting into this presentation is a lot of the time when we're speaking at various CEQA conferences, the goal is to help lead agencies get through the CEQA process as quickly as possible. And that, to be totally honest, is not our goal. Our goal and our mission at the Native American Heritage Commission is to protect tribal cultural resources. And so we want to do that in the best way we know how. Towards the end of this presentation, we'll talk about some best practices. And we always like to mention that some of those do extend beyond the actual requirements of the law, but it's just what we have seen that works best in actual practice of executing AB 52. We were just speaking about the fact that AB 52 is such a brand new law. And so there's a lot of things that we haven't really gotten definite answers with yet. But as of Tuesday, we actually got a new technical advisory from the Governor's Office of Planning and Research on AB 52. And so I have included that in the information that will be sent out to you. And so some of this information we've incorporated into this PowerPoint today. And so I apologize, there's going to be a few slides that are just big chunks of information. And that's because we haven't really had time to digest it all yet, but we wanted to make sure that you guys were getting the most accurate and up-to-date picture. So you guys are really just getting the verbatim text from a couple of parts of their technical advisory. So the purpose of AB 52, very broadly, was to make sure that the California Native American tribes are involved in the drafting of environmental documents as opposed to commenting on them once they've already been drafted. And so that's the goal that we have for this law. So kind of to go through our presentation, these are the different steps we'll get. The new technical advisory really gave us some additional wording for what tribal consultation is and what it's supposed to be. Then the goals of tribal consultation, be it AB 52 or otherwise, AB 52's procedural requirements, their substantive requirements, and then, like I said, we'll wrap up with the best practices, and then kind of the 5 most important things that you should know about AB 52. So if you fall asleep, I know it's right after lunch, through the whole process. Just get those last 5 things and you will be better off than you were when you walked in the front door. So this is one of those blocks of text I was talking about. So this is defining tribal consultation and what they're defining it as. And there are 2 different code sections. They cross-reference each other. Is the meaningful and timely process of seeking, discussing, and considering carefully the views of others in a matter that is cognizant of all parties' cultural views and, where feasible, seeking agreement. Consultation between the government agencies and Native American tribes should be conducted in a way that is mutually respectful of each party's sovereignty. Consultation should also recognize the tribe's potential needs for confidentiality with respect to places that have traditional tribal cultural significance. So that's a lot of information, but really that's it. That's what we're here to work with in terms of tribal consultation. We want to help lead agencies work with the tribes in a way but where both parties are getting their needs met. And one of the really big important things, and why I am the one that's giving this presentation now, is because I'm as they said during my bio, I'm a verified member of a tribe. So I've sat on both sides of it. I've sat through tribal consultation as a tribal member and seen some mistakes that were made and seen some very easily correctable things that could be done that instantly sort of set tribes on their heels. And so really entering into that meeting in a way to try to reach that mutual agreement and not to just check your box for AB 50, for your tribal consultation as quickly as possible. You'll notice there's a lot of crossover between AB 52 and SB 18. So this, the new technical advisory went on to kind of say that the tribal consultation guidelines were from SB 18 do carry over now for AB 52. And so I really wanted to highlight the idea that effective consultation is an ongoing process and not a single event. And the process should focus on identifying issues of concern of the tribes pertinent to cultural places at issue. So I think that's an important distinction. A lot of times we'll hear of tribes coming together, they have one meeting, they go away, there's no plan for future meetings, and the lead agency says yep, we met our consultation requirement, and the tribes are, no, we didn't, we barely just got started. So you want to make sure that you guys are both on the same page with that. So the goals of tribal consultation for planning is obviously getting the needed information in order to preserve the options of avoidance of cultural resources or preservation in place in the early planning process. So as was discussed earlier in the mitigation topic, our goal whenever feasible is to avoid, you don't have to mitigate something if you just avoid it. And so if that's possible, and that's why it's important to get tribes started or get tribes on board from the start, is they know where everything is, theoretically. They at least know where things are more than even we know at the NAHC. And so they can help you guide your project, because a lot of the times we've seen projects that if they had just involved the tribe from the start, it might be a matter of moving a building a few feet. And all of a sudden it's not on top of a burial anymore, and it's where the problem is solved. But if you don't involve the tribes and they don't tell you, and you don't know, then now blueprints have been drawn, permits have been issued, all of that, and now there's so much money out that you don't want to revisit those plans. So that's why we want to get the tribes involved from the start, because like I said, avoidance is always our preference. You want to build working relationships with the tribes that are traditionally culturally affiliated to your project area or your agency's geographic area of jurisdiction. AB 52 especially is really working to establish relationships between lead agencies and the tribes in the area. So understand that you're probably not going to be meeting with this tribe once and then you'll never see them again. You need to build ongoing effective work relationships with these tribes. And so that should always be a goal, is building that trust, building all of the rapport necessary so that you guys can have an effective working relationship. And that's not something we can teach you. That's something that will vary from tribe to tribe and from agency to agency, but it's important to go in with that goal. And then to avoid inadvertent discoveries of Native American burials with tribes in advance to determine treatment and disposition if burials are inadvertently discovered. That's really important. A lot of times we hear at CEQA trainings, we don't need to worry about AB 52, we're just going to exempt our way out of it. And that's fine if there's a valid exemption. But something that we always want to make note of is that if you do exempt yourself from that process and you find a burial, our most likely descendant statute is not under CEQA. So you cannot exempt yourself out of our most likely descendant statute. So what happens when an inadvertent discovery of human remains is found, all work in that area stops. They call a coroner out. The coroner then determines if they're Native American remains. If that determination is made, then they call our office. We determine the most likely descendant of those remains and then put the most likely descendant in contact with the lead agency representative. And then your options are really limited at that point. You have to either come to an agreement on the treatment and disposition of those remains. If that cannot happen, your only other option is to reinter those remains on the property in a spot that is not subject to further subsurface disturbance. So those are really, so if to the extent that you can avoid inadvertent discoveries, you have so many more options available to you at the start, whether as opposed to working your way around it and having to deal with it later. So some prerequisites to AB 52 consultation. It applies to any project where there's a notice of preparation, notice of mitigated negative declaration, or notice of negative declaration filed on or after July 1st, 2015. So by and large now, we're in AB 52 land. That was something, there was a lot of crossover kind of at the start. Maybe not shockingly, there was a lot of notices filed on like June 27th of 2015. But now, by and large, if we're talking about a new project, we're in AB 52 land. And then the second part is that a tribe that is traditionally and culturally affiliated to the geographic area where a project is located must have requested the lead agency in question provide in writing notification to the tribes of projects in the tribe's area of traditional and cultural affiliation. So that is one of the big changes, and we later in my presentation we'll go through the differences between AB 52 and SB 18. But one of the big things is that first step is the tribe sending that letter. But it's important to note the tribe only has to ever send one letter. Once that initial contact letter is sent to your agency, that's all the notice that they're required to give. Now it's on the lead agency to notify them of the future projects. And if there's ever a question of if that's an appropriate, like the notification letter is an appropriate one, we have a template letter on our website that most of the tribes, from what I've seen, have been using and that they're using, and it's just, you know, a fill in the blank sort of thing. That, you know, there's a spot for the tribe's names, there's a spot for your lead agency. So the 5 steps of the timeline and notice requirements, obviously first, like we're talking about, is the tribe request notification. Without this request, there is no requirement that a lead agency engage in AB 52 consultation, but it is important to note that failure to request notification does not preclude non-AB 52 tribal consultation. So we always kind of, if you're working with a lead agency that has worked with certain tribes in the past, and that those tribes have not sent out AB 52 letters, it still is wise to reach out to those tribes. And you're not engaging in AB 52 consultation, but to still just consult with them. And so we always recommend the more feedback you can get from the start, the better off your project's going to be, and the cheaper the fixes will be if there are any issues. Step 2 is notification by a lead agency. So within 14 days of determining that an application for a project is complete or a decision by a public agency to undertake a project, a lead agency must provide formal notification to the designated contact or tribal representative of traditionally or culturally affiliated Native American tribes that have requested notice under step 1. So we always recommend that in sending that initial contact letter, that you send that letter, and this is one of the things that goes beyond the actual letter of the law. We recommend that you send that letter registered mail with some sort of delivery confirmation, something along those lines. Because as you'll see, there's a lot of time constraints, but you don't know when a tribe has received that letter without knowing when they received the letter. So if you say, well, we mailed it on May 1st, it doesn't really matter when did they actually receive it. In this letter, should have a brief description of the proposed project, project location, lead agency contact information, and then notification that the tribe has 30 days to request consultation. So that 30-day clock starts when the tribe receives the letter. So again, you would want to know when that is. Then the step 3 is that the tribe has to respond and request consultation. So the tribe must respond within 30 days of receipt of the formal notification and request consultation. When responding to the lead agency, the tribe has to designate a lead contact person. If there is no lead contact person designated, then it defaults to the contact list that we maintain for SB 18 consultation. Before the lead agency, then it's step 4, begins consultation. So the lead agency shall begin consultation within 30 days of receiving the tribe's request for consultation and prior to the release of a negative declaration, mitigated negative declaration, or environmental impact report. And for the purposes of AB 52, consultation, as we discussed earlier, is defined now as the same, with the same meaning as provided in SB 18. So, conclusion of consultation. Consultation is considered concluded when the parties agree to measures to avoid or mitigate a significant effect, if a significant effect exists to a tribal cultural resource, or if a party acting in good faith and after reasonable effort concludes that mutual agreement cannot be reached. So, good faith and reasonable effort is one of those terms of art that we haven't really gotten into the weeds with yet. But my recommendation would be that you want to document all of that. One meeting saying, you know what, we're not going to agree and walking away from it, I wouldn't make your strongest argument that you were operating in good faith and reasonable effort. You definitely also want to inform the tribe that you consider consultation to be concluded. It should never come as a surprise to the tribe that consultation is over, because what you don't want is a tribe to show up at your hearing where you're trying to certify that document and say, consultation's not done, we're still here. So you want to make sure that you guys, even if you can't come to an agreement, that you're at least on the same page as to where you are in that process. So this is something new that just came out in the new report, which gives a little bit more of a description of what a tribal cultural resource is. So with the first one, we've already kind of knew this, that it was sites, features, places, cultural landscapes, sacred places, and objects with cultural value to a tribe that are listed or determined to be eligible for listing in a state or local register of historical resources or listed in a local register of historical resources. The important thing with that is that if that's the case, then we're done. There's no more discussion as to if it's a tribal cultural resource or not. If it's listed or eligible for listing on one of those registers, there's no more proof needs to be shown. Second to that is that if a resource that the lead agency determines in its discretion is a tribal cultural resource. So even if it's not necessarily eligible to be listed, there is still discretion with the lead agency to determine that it would be a tribal cultural resource. So we had always had the question of, how does a lead agency make that determination? So they gave us some options. So this is the real beauty, and from a tribal standpoint, of AB 52, is we now get to look at evidence such as elder testimony and oral history. I can tell you from my tribal perspective, and I always try to not ever speak for another tribe or say all tribes do this or no tribes do that. From my tribal perspective, we don't have written history. Within the last decade was the first time that we ever had a dictionary produced. And so it becomes really difficult because typically, you know, in the Western history, you're used to seeing written documentation. Maybe it's really old, maybe it's whatever, but you're used to having something on paper that you can look at. That's just not the tradition for many Native American tribes. And there's a multitude of reasons for that, but to discount oral history simply because it's oral is not your best bet to actually get this done effectively. We tell a story often during these presentations where there was a situation where an archaeologist from a lead agency said, there are no there's no burial here. And the tribe said, no, we have oral history. We've been told for generations that there's a large burial. And they went back and forth. The lead agency chose to listen to their archaeologists, and the tribe was right to the location of the burial within 50 feet. And that it was a huge burial, and that effectively shut down their project for quite a long time. Well, all of those remains, they reached a resolution for all of those remains. So it's kind of one of those things that we're going back to the initial slides of being cognizant of the fact that you might be coming from two different cultural places, that just because it's not written does not make it any less relevant. Going on, tribal government archival information, testimony of a qualified archaeologist certified by the tribe, testimony of tribal or expert witness certified by the tribal government. And we're really working with tribal governments now on how to go through that process, how to get expert certified. And so that's something I think you'll probably be seeing more of. Official tribal government declarations or resolutions, formal certified statement certified by a tribal historic preservation officer or TIPO, and then historical notes such as those found in Harrington papers or other anthropological records. So avoidance. You'll hear us preach about avoidance a lot. It is what we are mandated to do from our executive secretary, because like I said, when you can avoid something, you don't need to mitigate the damages to it. So avoidance is always our preference. And we have a public resources code that states that nicely for us now, which says that when feasible, agencies should avoid damaging effects to any tribal cultural resource. So, and then preservation in place is usually kind of looped in with that. I always like to stop here for just a minute and kind of give a little bit of perspective for that, because a lot of the times we'll hear, especially anthropologists, and there are great anthropologists out there, and especially archaeologists, and there are great archaeologists out there, they're trained to dig stuff up and study it. That is, putting it very, generally. And that is very counterintuitive to, again, I won't speak for all tribes, but at least from my tribe's history. There's a very spiritual belief that when someone or even something, it all has a life expectancy. And so that when that item or that person passes on, that you don't dig it back up. My tribe has a tradition where when someone passes away, you don't say their name for a year. And the idea is that you want to let their spirit rest and move to its next location. And so the idea, so it's been this kind of battle because it's cool old stuff and people want to look at it and they want to study it. But it's really just completely counterintuitive to what our tribal traditions and our spiritual beliefs are, which is that when something passes, in anything, be it a basket, be it a person, when those things, when their life expectancy comes to an end or their lifespan comes to an end, that you need to respect that and let it rest. And so that's why avoidance is so important for tribes, is because they don't want, generally, their stuff dug up and studied, because they believe that whatever that is, be it a person or not, should be afforded the same respect that to let them rest and to let that spirit rest. And so even for us, after that year of not speaking someone's name, that still, if you speak their name, there's something that roughly sort of is along the same concept as like, may she rest in peace. And so it's a general respect for that idea that they should be able to rest now. You've done your work in your life. You've done all the things you needed to do. Now it's time to let your spirit rest. And the best way you can do that in terms of the actual remains is leaving them where they are. So that's a small aside that's very important to me, because it's something I didn't always understand. I grew up very cognizant of my tribal lineage, but I didn't grow up on a reservation or on tribal territory. And so when we'd find, my grandma had these beautiful baskets. California tribes are generally known for their basket weaving. And they would start to get holes in them and different things. And I always thought, why don't we repair them? We can send them to someone, we can fix them, and then you can still use them. And she was always very clear in explaining to me that you don't repair something like that. Its job is done. So now you just let it be. And it's hard now because I see all these, it's a kind of a dying breed of people who can do this basket weaving and stuff. And so as these items get older, it's sad to see, but you have to respect the person who wove the basket and what it's kind of done its job. So if avoidance or preservation in place is not possible, then we can look at mitigation. Obviously, we had a wonderful presentation earlier on mitigation, so I won't go through it all again, but I do want to make a note that culturally appropriate mitigation for tribal cultural resources is different than mitigating impacts to archaeological resources, and appropriate mitigation measures should be identified through consultation with the tribal government. So this is, again, really putting a lot of the onus back on to talking to the tribes, because like I was just discussing, what may seem completely appropriate and even going so far as to honor tribes might be completely opposed to what their tribal practices are. So I've sat through tribal consultations where they said, oh, we found all of these really great remains. We're going to put them in a museum and we're going to honor you. And aside from the fact that it's a little weird to tell someone how they're going to honor you, seems backwards. But second to that is that was completely opposed to what we believed. So even though this lead agency had the best of intentions and was really trying to, honor our tribal history in this area, it was totally against what we believe. So I just like to always point that out, because we talk about mitigation on so many different levels, but in terms of tribal cultural resources, it should really be found through the consultation with the tribal government. Okay, so here's another really small slide for you. So mitigation examples. So these are some of the ways, obviously they're not specific mitigation examples. We had a whole presentation on that earlier, but the things that need to be taken into account when determining what an appropriate mitigation might be. And so those top three are really important: protecting the cultural character and integrity of the resource, protecting the traditional use of the resource, and protecting the confidentiality of the resource. There is no nice way to put it, but there is a huge market for tribal cultural resources. And we have had situations where people have wanted to do a big ceremony to rebury things, and then in the hopes of honoring the people in the tribe, and then in no time at all, sometime in the middle of the night, all of that stuff is dug up and gone. And now we're found, scouring eBay or doing different things, trying to find where these baskets are, where these pots are, or sometimes where remains themselves are. And so protecting the confidentiality is something we'll go into in depth more later, but is really important. A second option for mitigation is a permanent conservation easement or other interest in real property with culturally appropriate management criteria for the purposes of preserving and utilizing the resources or places. I just want to highlight C under California Civil Code 815.3, which says that a federally recognized or non-federally recognized California Native American tribe that is on the contact list maintained by our agency may be granted an easement to protect a California Native American prehistoric, archaeological, cultural, spiritual, or ceremonial place if the conservation easement is voluntarily conveyed. So that's something we're seeing a lot more of now. As tribes become more savvy with land use, we're seeing a lot of agencies just going ahead and conveying the portion of the land that is at issue to the tribe, and then they get to deal with it, and whatever they want to do with it is kind of up to their discretion now. So confidentiality. One of the big changes from AB 52 to SB 18 is the requirements of confidentiality. There were already confidentiality requirements under SB 18, but under AB 52, it basically changes it to an affirmative duty to keep items and documents confidential. So I won't sit here and read all of it to you, but just be aware of that change. Before, under SB 18, it was just exempted from Public Records Act requests and things like that. That still is the case under AB 52, but it also now shifts this. There's an affirmative duty to make sure that the documents exchanged or otherwise disclosed to lead agency are kept confidential. The exception to that is unless the tribe agrees in writing to public disclosure, the project applicant or project applicants shall use a reasonable degree of care to maintain the confidentiality of the information exchange. And so obviously the first item on there is to prevent looting, vandalism, or damage to a tribal cultural resource. So we have had situations where the tribe had exchanged information, and then once the project was done, it wasn't included. The lead agency did everything right. They didn't include it in their documents. It was in a confidential appendix, but whoever was in charge of their paperwork took it outside and dumped it in a dumpster. And then a reporter found it in the dumpster, found all of this information, and then went around and took pictures of all of the locations and posted them to a website. So the problem with that now is that information is now public. So you could argue that they violated their confidentiality standard, but in terms of actually having any legal authority to get it taken down, we had none. And so then we now had to call the owner of this website and basically just ask really nicely if you wouldn't mind taking it down. Because once it's made public, it's not covered under the confidentiality standards anymore. So that's why it's so important. And that idea is something that's really, it's something that we really hold tightly. And really, if there's any question as to if something is confidential or not, we really encourage you to reach out to the tribe or reach out to us, and we will help you get a better answer for that. So just to kind of wrap it up with confidentiality, they said no document prepared for public examination shall include information about the location of sacred sites. It does not protect the information from other forms of public disclosure. So with confidentiality, there are obviously some exceptions to that. So if the information is already publicly available, so like that example of the website, it was now publicly available. So now it was not covered under AB 52's confidentiality provision. Already in lawful possession of the project applicant before it was provided by the tribe. So that's something, that key is important, because if you already have something, even if the tribe determines it to be confidential, if you had it before they gave it to you, it's not covered under those confidentiality provisions. What would be a good suggestion, and something that we include later in our best practices, is you probably want to let them know what you have. So then that way, if it's later made public, they don't feel like you violated their confidentiality standards. So coming to the table and saying, here's all the information we have now, before you give us anything, here's what we've got. That way everyone is on the same page as to what is covered under confidentiality. And then of course, independently developed information by the project applicant or your applicant's agents, or anything that was lawfully obtained by a third party. So we're just going to spend a couple of minutes distinguishing between AB 52 and SB 18. So under SB 18, the law applies to all California tribes that are listed on our contact list, and then it applies to local governments that adopt or amend general plans or specific plans or create open space designation. Under AB 52, it's the same requirement for the tribes, but then it opens it up now to all CEQA lead agencies. And then what the law applies to are for SB 18, any adoptions of general or specific plans or open space designations. AB 52 is much broader. It's all CEQA projects for which a NOP, Notice of Mitigated Neg Deck, Notice of Neg Deck, is filed after or on or after July 1st, 2015. What triggers the law? For SB 18, it's the amendment or adoption of a general plan or specific plan or designation of open space. And the trigger is when the lead agency contacts the tribe. On AB 52, as we've discussed, it's when the letter from the tribe is sent to the lead agency for projects in their traditional or cultural affiliation. For SB 18, consultation begins when the local government contacts the tribes about the opportunity to consult. The tribes have 90 days to request consultation. Under AB 52, it's when the lead agency contacts the tribes who have made that request within 14 days of an application being complete or the lead agency's decision to undertake a project, and then the tribes have 30 days to request. So that's an important designation between that 30 and 90 days, because there are projects that will trigger both SB 18 and AB 52. And so you want to make sure that when you step in the room with a tribe, or before when you're sending the letters, that you are letting them know this is regarding AB 52 consultation, this is regarding SB 18 consultation, because there are projects that can also trigger Section 106. So there are 3 different rules for how you consult with tribes under those different guidelines. We get asked a lot if you can combine those consultations. If the tribe agrees to it, you certainly can. That's not something that we necessarily recommend, but when you do it, make sure that you are meeting the requirements of each one, and specifically the timeline requirements. So feel free, if they agree, if the tribe agrees, you can by all means do that, but be very careful with how you do it. For tribal consultation for SB 18, there's no statutory limit for the length of the consultation. For AB 52, there is no statutory limit, but the environmental documents cannot be released until consultation has been initiated, and they cannot be certified if there is a significant impact on an identified tribal cultural resource until consultation, if it's been initiated, has concluded. You'll see that about 7 more times in this presentation. That's a really important key. So how does consultation end? This is the same for both SB 18 and AB 52 when parties reach a mutual agreement concerning appropriate measures for preservation or mitigation, or again, if either party acting in good faith and reasonable effort concludes that their mutual agreement cannot be reached concerning appropriate measures of mitigation. And again, you definitely want to keep that all in writing and make sure that you and the tribe are on the same page with that. So under AB 52, there are mandatory topics of consultation if they are requested by tribes. This is another situation where we have a template letter that is available to the tribes, and they can literally just check the boxes of the stuff that they would like to consult with. So alternatives to the project, recommended mitigation measures, and significant effects, and then there are discretionary topics as well that they can also request. So, like I said, here's another time we're saying this. An EIR, mitigating neg deck or neg deck for a project with a significant impact on an identified tribal cultural resource cannot be certified unless one of the following occurs. The consultation process has concluded, the tribe requested consultation but failed to provide comments or otherwise failed to engage in consultation, or the lead agency provided notice of the project to a tribe and the tribe failed to request consultation within the 30-day guideline. And then if mitigation measures are agreed upon and recommended by staff, if the mitigation measures are agreed upon and then they are recommended by staff are not included in the environmental document, or if no mitigation measures were agreed upon, the lead agency still has the responsibility to consider feasible mitigation measures pursuant to section 201.184.3. So these are, as we're wrapping up, just kind of the consultation best practices. So these are there are a couple points in here that do extend beyond the actual letter of the law of AB 52. But what tribal consultation should be is the goal should be to discuss mandatory and discretionary topics requested by the tribe, particularly significance of tribal cultural resources, avoidance, preservation of place, and/or mitigation measures, achieving resolution on those topics, or if resolution is not possible, to document why and what efforts were made. What it should not be is an information exchange. We recommend that you exchange that information beforehand, so that then you can come to the table with once the AB 52 clock is running and be ready to actually reach some resolutions. If your first consultation meeting is just an exchange of information, the clock has started, and you want to make sure that the tribes are prepared to. We want to make it as productive as possible. So before you begin, and this is just a couple of notes, and these are things that I have seen being on the other side, on the tribal side of AB 52 consultation. Understand that tribes expect to be respectfully engaged and expect their proposals to be thoughtfully considered, even when not expressed in technical language. It's really important to realize, especially in California, that there's a huge gamut of what a tribe is. There are federally recognized tribes with huge casinos that have a ton of money and have archaeologists on staff, anthropologists on staff, ethnographers on staff, have huge cultural resource centers, have the means to really come to the table and can just speak your language in terms of CEQA in project proposals. Then you have tribes like mine, which are not federally recognized, which do not have a budget. Everyone who is sitting at that table with you has another 9-to-5 job. They're doing this really just out of the passion for protecting their ancestors. And so a lot of the time, and most tribes don't have someone like me who has a law degree. Like a lot of the times, these are people who have had very blue collar jobs their whole life, and they don't know how to say it in the right language necessarily. They know how to convey the fact that these items are important. And so it's really important to give both of those tribes, the one with all the money and the perfect proposals, and the tribe sitting around at a fold out kitchen table with you explaining why something is important. You want to give those tribes the same respect. On that same level of respect, understanding that tribes don't want to be persuaded into accepting your preconceived plans. I've sat through tribal consultations for my tribe where someone literally came in, slid a plan across the table to us and said, take it or leave it. Like, that's not consultation. That's coercion. And so that to them, we were an interest group. We were another Sierra Club, we were another whatever. And so they said, this is what we're going to do. We hope you guys like it. And that project did not go very well for them. And so just understand that the whole purpose of AB 52 is to get tribes involved from the start, and to get them involved before documents are being drawn up, so they can really help you create the best project possible. Do your homework before you start to engage in this consultation. Request sacred lands inventories and CRIS searches to find out the cultural resources in your proposed area. It's really important, but understand that either one of those searches are the start of your research, not the end. There is nothing that requires tribes to list their sacred lands on our sacred lands inventory. As much as we feel like we are here and helping to protect tribes, we are still the government. And anyone who's mildly familiar with California history knows that the relationship between Native American tribes and the government is not a great one. So a lot of times they don't trust that our information, even though we go far and beyond to make sure that it stays confidential, will. So it's a good way to start. But I sat through a training one day with a partner of a law firm who said, well, we did a search on your sacred lands inventory and nothing came up, so we're good. Nope. So don't do that. And but it is a good place to start. And then request a AB 52 list of the tribal culturally affiliated tribes of the area. You want to research the current tribal leadership. The Office of the Tribal Advisor has a California Tribal Directory. It was published in 2015. They're in the process of doing an update to it now. You want to know the areas of additional or traditional and cultural affiliation. Newspaper articles of your tribe's concern or any other indication of tribal concern to your project. This is when Google can be a big help to you. A lot of times, if a tribe is aware of a project going on, they might have already spoken out in some way, shape, or form as to their opinion of your project. It's always good to know what you're walking into. And then along those same lines, other projects which your agency has consulted with the tribe and how that consultation process went. It might be your first time meeting the tribe, but they might have met with your agency a dozen times. And if that's never gone well, you want to know why and what you can do to make it better. Ethnographic studies, documenting the confidential tribal cultural resource information already possessed by the lead agency. That's what I kind of talked about before. Geotechnical and archaeological reports, and then consulting with tribes in the culturally affiliated areas in advance. So that would be when you can have your information exchange. Review the SB 18 before sending out your notice. Formal notification of your project. You want to take time to review the SB 18 consultation guidelines, this new technical advisory. And since avoidance of damaging effects of tribal cultural resources, if feasible, is required, be prepared to consider avoidance or explain why it isn't feasible. And that's really important because we don't want to hear it's not feasible because we don't want to have our project anywhere else. Like that doesn't make it not feasible. And then when sending your consultation notices, you just really want to make it clear it's for AB 52 consultation because there can be multiple consultations triggered by one project, and include the statutorily required information. And then this is, again, sending your notice return receipt requested so that you know when the document was received and when when the clock starts. Just some more tips of when you're sending your consultation notices, you want to include, if your lead agency has a policy on discretionary determinations of the significance of tribal cultural resources, include that. That way the tribe knows what information you need. And the more information they can have from the start, the better. And then make sure to seek the tribe's agreement on the consultation agenda in advance of beginning consultation. Again, the more you can get on the same page with the tribe from the start, the better. Consultation, you just want to make sure to keep your consultation government to government. I've sat in quite a few consultations where they walk in and shake the chairman of my tribe's hand and say, "Nice to meet you, Don." It's the effect of walking in and shaking Governor Brown's hand and saying, "Nice to meet you, Jerry." You just wouldn't do it. And it comes across at that same level of respect. They are independent, sovereign nations. You need to treat their officials with that same respect. And then know who will be representing the tribe and follow protocol, knowing their titles, and introduce all your participants and explain who they represent and why they need to be present. That's important. Tribes don't generally want to walk into a room full of people because it's confidential information they're discussing. The more people in the room, the more opportunity it has to not be confidential anymore. And then do not share tribes' confidential information with another. You hear that a lot because, for example, I'm a Mountain Maidu. There are 6 other Mountain Maidu tribes in our area. So I have first cousins that are in another tribe. So a lot of the time, people kind of start to group them together. But a lot of the time, they're in different tribes because they don't get along. And so you don't want to start sharing information back and forth between these different tribes. It is confidential to that specific tribe. And so when another tribe doesn't want to hear is, "Oh, well, they said that area is fine." It just doesn't matter. And so you want to make sure that confidentiality is respected between tribes as well. Keep the consultation documented in real time. And this kind of goes back to not ever surprising a tribe that consultation has been concluded in your mind. And then if an agreement was reached on mitigation measures, inform the tribe that the mitigation measures will be recommended for inclusion, but that doesn't mean that they will be included. And then document all areas which agreement was reached or not reached. And if consultation is unilaterally concluded, be able to document that the requirements for doing so have been met. Following consultation, you just want to review with your lead agency and staff how it worked. Like I said, AB 52 is still very, very new. And we want to make sure that this is an ongoing and evolving process. And so hopefully your first consultation is going to be the roughest. Hopefully they keep getting better. So taking a moment to review. And then just to wrap up, the 5 most important things to know about AB 52. Unless a tribe requests notification of a project in their area, there's no AB 52 consultation obligation with them. Lead agencies have an affirmative duty to use reasonable care to protect confidential information received from tribes through consultation, with the exceptions that we discussed before. An environmental document cannot be released until consultation with the tribes that have sent notification and consultation requests have been initiated. An EIR, mitigated neg deck for a project with a significant impact on an identified tribal cultural resource cannot be certified or adopted until AB 52 tribal consultation, if requested, has been concluded. And if mitigation measures are agreed upon with the tribe, the measures must be recommended for inclusion in the environmental document. So that is it. Just some contact information. We are here to help. We get that this is new. We're still figuring it out ourselves. So we really encourage you, if you have any questions, to reach out to us. I listed our general counsel because she's the best. And then myself, and then Rob Wood, who is one of another analyst from our agency, and he was really who led the AB 52 implementation as far as on our agency side. And then we continue to update our website for guidance. We have a bunch of PowerPoints up there. We have tribal training. We have a lot. It's a lot of information. So check that out. But really, if you guys have questions, please do not hesitate to ask us, because we'd much rather answer those questions ourselves than have you guys go out and try to figure out the answers on your own and not be successful in that. So does anyone have any questions for me?
So I am a cultural resource consultant.
Okay.
And one of the things that I run into frequently with clients and with smaller lead agencies is confusion over who can actually be part of consultation.
Mhm.
And could you speak briefly to how an applicant or a consultant like myself would become part of consultation? Because a lot of our applicants think that they can just walk right in and be part of the process.
So we encourage all of the consultations to remain government to government. So if you have the authorization to speak on behalf of the agency that you're working for, then I can't say that you have to be included in that. That's never the case. But then generally most tribes, I feel like, would be open to that. Where we see a lot of issues is when they want everyone from the person who answers their phone to, you know, their sister in consultation. And that raises a lot of red flags for the tribe, just purely on confidentiality standards. So if I were you walking into a meeting, first of all, I'd obviously make sure to have the authority to be there on your agency's behalf. But then I would explain why you are there and what your purpose is for being there to the tribe. And be prepared for the fact that they can't ask you to leave. And that is something that we do see. We have a couple of tribes that we work with a lot, and one of the attorneys for that tribe, when she walks into tribal consultation, will just walk around the room and say, like, who are you and why are you here? And if she's not satisfied with your answer, she will ask you to leave. So, and that is 100% in her right to do so. Any other questions?
Any other questions?
So I'm very curious about the aspect that information provided by the tribes should not be included in the environmental document, vis-a-vis the general purpose of CEQA documents to disclose information to the public. And the idea that you're protecting it for the sake of one sector of the public, the tribe, but you're depriving it of other sectors of the public. So I understand the basic respect and the information, and you can do that. What then do you put in the tribal cultural resources section of the document? Well,
we recommend you put the actual confidential information would be included in some sort of confidential appendix. But in terms of the actual verbiage of it, it doesn't mean that you can't discuss anything at all. The confidentiality stuff really comes down to like the specific locations, things like that. So saying this is an area of concern is fine, or that, you know, our sacred lands file returned results, that's fine. You just don't want to get into like the specific results or the specific locations of things. So it's really just all about kind of protecting everything as it lies at that moment as much as possible. And if you're unsure, I would talk to the tribe about it and say, you know, this is what we're looking at including. Are you comfortable with that? And if you're not, and if you want more, you know, assurance, you can always reach out to us, and we'll do our best to give you some direction with that too. But I think when in doubt, working with the tribe and saying this is what we're looking at including. Are you guys comfortable with that? And kind of getting their sign off would be the best way to go.
I'd like to get some of your feedback regarding meaningful consultation and what generally that would entail. I know with both AB 52 and SB 18 and Section 106, part of and it often is, you know, government to government. Let's say you have a federal lead or even a local lead for that matter. Send letters maybe to first contact the tribes and let them know what the project is, or maybe through 106 they contact your office and then get the list and then send out, you know, typically it's a letter to start. It's not uncommon, as I'm sure you're well aware, that there's no response received from the tribes, and taking into account the fact that you mentioned that not all the tribes have the staffing or the sophistication or so forth, I can expect that they get lots of letters for various projects. Who knows how often they check their mail and, you know, so forth. So notwithstanding, how many times do you think it's appropriate to try to reach out? I know from working with other professionals in the archaeological realm, particularly that work for governments, they have personal relationships with a lot of the tribes in their areas and jurisdictions. But at what point is it appropriate for a lead agency to make the determination that they've reached out, they followed up with a phone call, they followed up with an email, that the tribe's just not interested in engaging in that consultation?
It's a hard question to answer because there's not like a number. There's not, obviously making a concerted effort, as long as you're meeting the statutory requirements of sending the letters, making sure that they've actually received them, all of that, that's the statutory requirements. If you are having a really hard time reaching out to, getting a response from a tribe, you can always call us. We can put you in contact with the analysts. Kind of the way our office is set up on the environmental side is that there's analysts that cover the entire state, and they're just divided up sort of by regions. So we can always put you in contact with the analysts from that region, and they might be able to give you some additional ideas, or reach out to the tribes themselves and say, hey, this agency's trying to get a hold of you. Are you guys really just not interested, or what's going on? So you can do that. I don't have a, perfectly specific answer to that question, just because it's something you kind of just have to use your best judgment on. The more attempts, the better, of course, but obviously you're on a timeline and we're cognizant of that. So if you reach out to our agency, if you aren't getting a response, maybe we can give you some direction, because too, addresses change, things like, there are those other issues, and that's something that tends to be an issue more for smaller tribes, because half the time their tribal office is like somebody's house, and so, or a PO box or whatever. If you're trying to get a hold of a Pechanga or United Auburn, like their address, they're not moving. But the smaller tribes, a lot of times, I can speak, ours is a PO box that's just in our local post office. So and we do my tribe. We have 462, I believe, lead agencies on our list. So just sending out the initial contact letters was an undertaking financially, just for, postage and paper and stuff. So that's something that, they try to keep up on. What we ended up doing, and what we recommend to a lot of tribes who are in that same kind of situation, is we just kind of cherry picked and said, these are the agencies that we work with a lot. These are the agencies in the areas that we really care about. These are the agencies doing the projects that, we tend to see a lot of. So we cherry picked and decided to take that method with it, but tribes can kind of do what they want. So I don't have a great answer for you, but I would just say using your best judgment and then reaching out to us. Especially if it's a continued issue, or if it's a big project, you definitely don't want them to show up and say, hey, we sent a letter and we never got anything. Then that can kind of tend to, you don't want that to happen. So whatever, we'll try to ensure that that doesn't happen in any way we can. Yes. Oh. Here. Yeah.
Thank you. A lot of times one of the requests is for construction monitoring. And what do you do? I've been involved in situations where there are multiple requests for construction monitoring from multiple tribes. And is there any way to resolve that, to have agreement on one monitoring? What do you do when you have multiple requests that if something is located, it goes to or discovered, it goes to a particular tribe, as opposed to the other tribes who have the same requirement? So in terms of the consultation, if you have inconsistent requests, how does that generally get resolved?
So in terms of monitors, that is something that from the NAHC side, we do not involve ourselves in monitoring. And that is simply because we would then be taking a sovereign nation's right away from them to request those accommodations. It's not something, that it is a common problem and we're very aware of it. We just don't have a really great way to handle the problem without starting to infringing on sovereign nation status. So again, sorry, I don't have a great answer. In terms of, what to do if things are found, stuff along those lines, you would want to, you can reach out to us and we can help you work out a way that would maybe be a little bit more streamlined, because I'm aware of the fact that it's a big income source for a lot of tribes with cultural monitoring and everything. So we are aware that can become an issue. In terms of the monitoring side, like I said, it's not something that we can really weigh in on, but in terms of where the items go, that is something that we can help you work with the tribes to develop a plan.
Hi, I'm from the city of Orange, so the lead agency side. You had a bullet point that went by quickly about sharing the lead agency's policy on discretionary determinations on the significance of tribal cultural resources. Do you have any suggestions, any resources for how we would go about developing a policy like that? Because I suspect that Orange, like a lot of other small jurisdictions, don't have those policies in place.
Yeah, and that's common. So don't feel like you guys are not doing, but we are seeing more and more, especially with areas that have a lot of tribes or have a lot of, there's a lot of areas of cultural sensitivity. If you go ahead and email me and I can try to send you, I don't know that I have like a template per se, but I can see if I can find one from another agency that wouldn't mind us redacting their information and giving it to you guys at least as an idea of where to go. But yeah, and looking in that, but it's something that you guys would have to look at it from a governmental side of what you want that policy to look like. But it is something we're seeing more and more, because it does help consultation move faster. If you say, like, this is our policy for determining this, here's what we would need you to show, and then the tribes can say, like, here you go, and then it moves the process along much faster.
Do you know if any of those policies have been developed in consultation with tribes?
Yeah, quite oftentimes, because a lot of times, like I said, initially, is what most people would want. It's like, well, can we have your, some sort of textbook or some sort of written map or something? And they don't necessarily have that to show. So what might work well with the tribes in your areas? How is your history shared? How was it passed down from generation to generation? And kind of figuring out that side of it first. And so then when you're developing what standards you would want to use, you can take that into account. Because obviously if you walk in and say, oh, we need to have, a written map or a written list or something, no tribes, I shouldn't say no, but a lot of tribes aren't going to be able to prove that. So you want to make sure that whatever your standards are effective for the tribes in your area. And that will vary from group to group.
Thank you.
Mm-hmm.
Okay, one final question, and we might need to move forward here.
Sorry.
Hi, going to confidentiality, when we do a record search with the information centers, a lot of the smaller lead agencies don't understand that the information centers really want to have a designated person who is registered with them in the lead agency, who is the only person or the limited amount of people who get to handle the archaeological information. Is something similar being developed with tribal information, that there's like a designated person or two?
I can't speak to Chris because that's not our agency. I can, in terms of the Sacred Lands file, we don't have a requirement for that. What we do have a requirement for, or we are working on one, is that a lot of the times we are getting requests from consulting firms or from, non-lead agencies that are working for lead agencies, but they're not always great about actually telling us what who they're working for, basically. And so that's something that we struggle with a lot, is then we have to contact them and say, well, why do you want this information? And then going from there. To my knowledge, and I don't do those searches, that is on our environmental side of the office. So I will try to find a more specific answer for you and get back to you on it. But to my knowledge, we don't require that. But we are, like, as one specific person or anything, but we are requiring now, especially with third parties, to acknowledge or to determine who are you requesting this information for, what project are you requesting it for, all of that, so we're not just sending it out. I mean, there's no actual, the results you're going to get are not specific enough to really do generally a whole lot of like damage, but we want to keep it as confidential as possible. So
it's something lead agencies are always asking people advice.
Yeah.
So if I had an answer where I could actually pre-warn them, look, you really need to limit the circulation of this information to 1 or 2 people only. And if you just let it open to everybody, then you're getting into trouble. If I could have some guidance on what I could tell them when I get those questions, I get that frequently.
Yeah, I would, really going over the confidentiality standards and it's now, there is now that affirmative duty to keep the information confidential. But then in terms of actually just requesting the information, I would want to, it's the most effective to do it as kind of with 1 or 2 people, just because that way it's all coming together. Because we oftentimes too will get like a bunch of requests for the same project. It's like, oh, that these different lead agencies all are working with different consulting firms and no one's talking to one another. So kind of encouraging that cooperation is important too. So yeah, and that's something kind of important in terms of the responses that you'll get, at least from our agency, for your Sacred Lands file search. The Sacred Lands file search will either say there was nothing came up for this search, you need to contact the tribes in the area, or something came up, you need to contact the tribes in your area. So the end result is always the same. So that's why we always warn people when they say like, oh, we did our Sacred Lands file search, nothing came up, so we're good. Like, did you read the second half of the letter of, that you need to reach out to the tribes in the area. So yeah, and we are really encouraging, especially state agencies, that everyone needs to develop their own tribal consultation policy and appoint some sort of tribal liaison or some sort of tribal contact. So then that way the rapport and the relationships are getting built with the tribes, with one person.
To both of those points, another thing you could point the lead agency to is there is a requirement in AB 52 that a point of contact be named in that initial letter. So you could tell them that is an indication that AB 52 means for the tribal information and the tribal consultation to go through one particular person. And there's a good reason for that, so that the tribe isn't like bounced around to a bunch of different people and they know who it is who speaks for the lead agency.
Yeah, and that's really important too in terms of consultation, is that idea that whoever is in the room or whoever they're working with actually has the kind of sign off of the agency to be doing what they're doing, because that can get really messy at times when there's a bunch of different people reaching out to the tribes and then they're kind of repeating their information, especially when you're dealing with a tribe like mine who doesn't have someone sitting there necessarily from 8 to 5 to deal with all of this stuff. And so now they're like, I already told these 7 other people this story. It makes it, having that one point of contact is good. So yeah, that's a completely valid point. Like mentioning the fact that you have to have some sort of point of contact is definitely indicative of what the purpose is.
So I will suggest, I just need enough time to set up chairs here for the next discussion. So less than 5 minutes for sure, but just enough to use the restroom and grab some water, and we'll be right back here.
Thank you guys so much for your attention.
Samantha.